Okay, I have 132. So let's go ahead and get started because I know there's going to be lots of questions on this topic and I want our speakers to have plenty of time to get to them for you. If you could just go ahead and mute your microphones for us so we make sure that we've got audio sounding really good for everybody. And I will keep admitting people as we come in here. I do want to do a little bit of housekeeping for everybody real fast. Welcome to today's Will and Estate Planning session sponsored by Chicago Title. The Realtor Foundation has long believed in providing my board members with the tools to prepare for your future. And we have lost many long-time and influential realtors who had no plans in place, and that fact was both devastating for their families and for their business. There are many charitable opportunities available to you as you develop the best plan for you and your family. And if you would like information about how you might include the Realtor Foundation in those plans, please reach out to me for some more information. Before we get started today, just a couple housekeeping items. If you just make sure that you stay muted for us unless you're asking a question. You can enter questions into the chat box, and I will give those to our speakers as we go along, or we'll hold those to the end. But make sure you use that chat, and I may ask you to unmute yourself and ask that question yourself as well, or I can relay it to our speakers. As time allows, we'll get to as many of those questions as we can. Otherwise, I'll make sure that you get connected with today's speakers so you can get those questions answered as well. We are recording today's webinar, and we'll share the link to this session and our prior two sessions at the end of today. I'm also pleased to thank our sponsor, Chicago Title, and Tanya Ott is with us today. Tanya, have anything you want to add before we get started today?
No, not anything at all. Just looking forward to a great session with a lot of questions.
Good. Now I'm happy to introduce our speakers. We have with us today, Elizabeth Schluter is an attorney and owner of Schluter Bremen, LLC. In 1992, Elizabeth graduated from the McKinney School of Law in Indianapolis and began serving families in the areas of will, trust, guardianships, and estate settlement. Her legal career began in a small law firm in LaGrange and moved to Fort Wayne, where she served as trust officer and associate trust legal counsel for what is now known as JP Morgan Chase. Her most recent prior experience as the chief family office strategist for Oxford Financial Group and the chief fiduciary officer for the Trust Company of Oxford allowed her to continue her passion to help clients fulfill their financial legacy for their families and communities. In addition to her work with her clients, Elizabeth has shared her knowledge in several noted publications, including the New York Times, the Wall Street Journal, Financial Advisor, Bloomberg News, and Forbes.com. She's also an accomplished speaker on will and trust planning issues, and we certainly saw that yesterday. Tanya Ott is the sales and marketing manager for Chicago Title. She recently celebrated her 29th anniversary with Chicago Title this year. Congratulations, Tanya. She started with the company in the escrow department and quickly moved into handling closings, and she has personally conducted over 3,500 transactions. She has seen the good, the bad, and the ugly that comes along with closings. I'm sure of that. Today, her primary role is business development through leading, inspiring, training, and supporting the best sales and marketing team in the business. And I know that there are a lot of them with us today because I can see the names. Ladies, please take it away, and we all look forward to a great conversation.
Thank you, Gabby. We really appreciate it. All of you who were with us yesterday, thank you for coming back today. Our focus is a little different today than it was yesterday. Yesterday was designed to begin a conversation with you individually about your family and your personal planning. Today is much more about how you continue to represent your clients that are going through some of the difficult transitions that we talked about yesterday. And so what we're going to talk about today is things that you might need to know if you're representing in a purchase or a sale someone with a power of attorney, someone under guardianship or with a guardianship, someone who is representing an estate, both supervised and unsupervised, and potentially the trustee of a trust. And what we want to do is help you avoid some pitfalls that I think Tanya and I have both seen in these situations that can hold up timing, even to the point where it can dismantle your whole transaction. And so we want to help you avoid that. So Tanya, anything you'd like to add?
Nope. Let's go. Let's move forward.
Okay, so I have a little technical difficulty here. All right, so let's go to our next slide. Let's see. I'm sorry, you all. I am trying to get it to go forward, and it's not moving forward for me. Let's try that. Nope. So we're just fine yesterday, and for some reason I'm having a little bit of trouble today.
I have your slides, Elizabeth, if you want me to run. I don't know if you've made updates to it from the last one that you've done.
No, I haven't, Gabby. If you wouldn't mind doing that, I'd appreciate it. I'm not really sure what's happening. But we'd want to go to the next slide, or a power of attorney slide, or can I sell the real estate, which is really a question that you want to make sure you have a very solid answer on as you're going through this next section. And the real issue here is, if we go back one, Gabby. There we go. Is the power of attorney and whether or not, first of all, the power of attorney is in effect. We talked a little bit yesterday about limited powers of attorney, where you all have probably seen this. Someone potentially can't attend a closing, and so they grant a power of attorney to their spouse or their significant other so the transaction can be concluded, and that power of attorney has a very limited scope. There are other powers of attorney that we also talked about yesterday in a more individual way that are general powers of attorney. Those powers of attorney have even more authority around this kind of transaction. In fact, around a purchase or a sale, it allows the person who is named in that power of attorney to do anything that the person that the power of attorney is for has the legal authority to do. The one thing that a couple of things you want to check is, first of all, it would be good for you to get a copy of that power of attorney. And the first question you're going to ask yourself is this a general or a limited? So you're going to see what the scope of the power of attorney is. The second question you're going to ask yourself is this power of attorney in effect today? We talked yesterday a little bit about powers of attorney that only become effective upon incapacity, and that sometimes you need that writing from the doctor attached to the power of attorney. So you want to make sure that in the case of your purchaser or seller, that they have the legal authority because that document is in fact effective. The other thing that you want to make sure is, and I think this is really important, is that power of attorney has been recorded in the county recorder's office. If it has been recorded, then that legal authority is recognized, and there shouldn't be an issue with that person concluding any documentation that's required on that transaction. So Tanya, is there anything else you'd like to add around powers of attorney?
Yeah, just a couple of quick points. If you're dealing with a purchaser that's wanting to utilize a power of attorney, if you have a financing lender that is involved in that transaction, they have to allow for a power of attorney to be used to execute the mortgage documents. So that's a first and immediate question to kind of check off the list, because there are some lenders that have their own specific document that must be executed. And sometimes they have restrictions on who they will allow to act as power of attorney. They may restrict it, solely to a spouse and not, some other disinterested third party. So that's kind of number one. Second matter is the vast majority of power of attorneys that we see for closing have not been recorded. They've recently been executed. So in the probably 1% of the time, they've already been recorded. And one of the big things that we have to do as a title company. One is when you send it to the title company, whether buyer side, seller side, they're going to look to make sure that it allows for transfer of real estate, but they're also going to make certain that it meets the county recorder's requirements in terms of required verbiage and so forth. Because if the county office is going to reject that document and not allow it to be recorded, then no subsequent documents can be recorded, a deed or a mortgage, if that's the, if that's what's being used to execute either of those things. So in some cases, a new power of attorney does have to be executed because it lacks required verbiage, or it doesn't fit into the county's requirements to be accepted for recording. So that's all I have to add.
Sounds great. So the next situation that's even a little more restrictive than the power of attorney is when your transaction involves a guardianship. And so one of the issues around guardianships is that they are court monitored situations. In every situation, we're going to see in estates there might be times where you don't need court authority in order to execute a transaction. In a guardianship, you almost always need court authority to execute a transaction. And if you remember what a guardianship is, it's a situation where someone has been deemed legally incompetent, and a court has appointed someone to act on that person's behalf in regard to that person's financial affairs. So a guardian has the legal authority to sell property, but because the transaction is normally a fairly significant part of the incapacitated person's financial situation, the court almost always has to approve that. What I want you to talk about with your clients in that is that normally that means that if you're on the seller side of that transaction and you're representing a guardian who's selling property, this happens a lot when someone is trying to become eligible for certain state benefits such as Medicaid. You need to be in a situation where if the property sells before the court has had an opportunity to opine on that sale, that in your acceptance of that offer, you make sure that you denote that that offer is subject to court approval. That's really, really important. And then you want to make sure that your seller, that your guardian has been in contact with their legal counsel as quickly as possible to put that request before the court, because sometimes there can be as much as a 30 or 60 day period of time before the court's willing to determine whether or not that sale can take place. So you want to make sure that you get that done as quickly as possible around the proposed acceptance of that offer that you can, so that you don't lose that opportunity, you don't lose that purchaser because of a timing issue around when they want to assume the property. Usually, in my experience, the title company then wants court documentation showing that the court has approved that sale and that the transaction can move forward. Tanya, would you like to add any additional color around that?
Sure. Just very quickly, when the title search is completed, that guardianship will be pulled up as part of our research on producing the title commitment. And we do list all of the requirements in terms of what documents are needed. Typically, we will communicate directly with the attorney's office, or certainly that's something that the guardian can do, but we're willing to do so just to make certain that everything is in fact meeting court approval and so on and so forth. And what's interesting is in the 29 years I've been with Chicago Title, I had maybe come across one guardianship closing personally, and we've had 3 within the last 45 to 60 days. Just wow. It very, very interesting. We don't see them terribly often, as they're not terribly common, I should say, but we've had an instant sort of rash of them. So that's all that I'll add is we'll line out everything on the commitment that's required and communicate with the attorney as needed to obtain those documents. But as you mentioned, the timeline in terms of how quickly the court will act and approve, a petition to sell varies, and there's not really much control, over that time frame that any of the parties really can manage.
No, that's really important. And if you're representing a purchaser in that situation, I think setting expectations with your purchaser that there's nothing, it doesn't reflect any kind of issue or defect or problem with the real estate if it takes a little longer. Unfortunately, it has to do with court timing and calendars and all those kinds of things. And so we just want to set good expectations on both sides of the transaction so that you don't lose that opportunity just because someone thought, oh, I thought we could do this in 30 days and now it's going to be 60.
Mm-hmm.
Okay. So the next situation that we run into a lot is what kind of documentation do you want to kind of think about when you are looking for other ways that people sell property? And so, I think most of us think, well, we're going to put our house up for sale. If we're married, we assume that both of the people that are in the relationship own the property, and we just kind of go forward on that. One of the things that I would encourage you to do, and most of you probably already do it, but just a good reminder, I think, is that when you're representing a seller or a purchaser, that you ask very specific questions about who does legally own the property. We see situations where, maybe one spouse had a credit problem when the property was purchased, and so it didn't make sense for them to be part of the purchasing party. Or maybe it's a situation where they got married after the home was purchased and they moved into someone's property and we just never took the time to put somebody else on the deed. Those kinds of things can just get sticky again with your documentation, and not that it causes a problem, but sometimes people get so nervous because this is such a significant transaction for most people. Most of us, this is the most significant investment that we make is our home, that it can be a little nerve-wracking if things don't kind of clip along at a very kind of expected and measured way. And when things come up, it can be I think frustrating for people, and we don't want you in that situation. So ask who legally owns the property. Ask if the people that legally own the property are the same people that are legally on the mortgage. I know we all think, well, of course they are, but that's not always the case. There are times we've seen where people have purchased a property, one person purchased it, got the mortgage, and then they quitclaimed part of their interest to their spouse. So their spouse isn't technically on their mortgage. Is that a violation of their mortgage? Could be, but that's the fact that we deal with when we're in the transaction. And so we want to make sure that you ask all of those questions and you understand how that can impact where you are. The other thing is that when you're talking with someone who's in this period of transition, you want to make sure that that person has legal authority to enter into those transactions. We do see lots of situations where, unfortunately, a husband or a wife has passed away, and really the only thing the couple owns is the home, and because of an issue, maybe the person who passed away was the owner of the home, and the survivor thinks automatically, well, that's my house and I can do anything I want. I've lived there for 15 years. And the fact is that legally they don't have the authority to do that yet. So there are additional steps that have to be gone through. Again, nothing that can't be fixed, but it causes delays and it causes frustration. So making sure that they have the legal authority, making sure you understand who owns property, making sure you understand who owes money on property, and understanding whether or not there's any other legal obligations around that, I think are a really important part of the beginning of your relationship. Tanya?
I don't have anything to add on this slide. Thank you.
Okay. So now we're going to move into what happens if you transfer title another way. And we just want to make sure, again, we talked a little bit for a moment ago about tenants by the entirety's property and joint tenants with rights of survivorship. One of the things that we find a lot is that even though we talked about yesterday that title passes automatically by operation of law, when it isn't documented, it can hold up a transaction. So if my husband and I own our home together and he passes away, and then a couple years later I decide that I want to sell our home, if I didn't file the right documents with the recorder's office before that, there's going to be an additional step that needs to happen. That also means additional costs because someone needs to put that affidavit together, and that affidavit needs to be filed. So you just want to make sure that you really do understand that ownership and what that looks like and what you need to do. So if you have joint tenants with rights of survivorship, which typically means that people that aren't married own that property together, there needs to be an affidavit of devolution that has been recorded with the appropriate county recorder's office. Again, as Tanya pointed out before, we want to make sure it meets all the recording requirements and it has been appropriately recorded. That does take that person who's passed away off the title and allows for clean title to pass. If it's a situation where it's tenants by the entireties, that affidavit is called an affidavit of survivorship, and it says that the surviving tenant by the entireties now owns 100% of the property. So just some things, additional paperwork that you might want to look for, especially when you're representing a seller. Tanya?
The one thing that I will add is oftentimes, I would say a very small percentage of the time when we find ourselves in that situation where someone has in fact passed, very seldom is there an actual affidavit that's already been placed of record, which we obviously will arrange to have those documents prepared. However, anytime someone passes away that's held title in whatever capacity, whether it's tenants by entireties, husband and wife, tenancy in common, we will always request a copy of their death certificate. That's a common practice for a title company, one, because it does in fact verify that that individual is no longer with us, but it's also used to be able to reference the date of passing to either prepare a separate survivorship affidavit or insert a survivorship clause within the body of the deed, which will then obviously alert the county of the reason why a particular party is not executing the document, and will allow for the transfer of title as well as the transfer of the real estate taxes.
Okay, so the next thing we're going to talk about is transfer on death designations, or as I like to refer to it, which kid do I love the most? One of the things that we want you to be aware of, and we've had questions on this in our office in the past couple of months, is when you do a transfer on death designation, what legal right does the person who's named on that transfer on death designation have? Like, do I have the right, if I am on my parents' deed as a transfer on death designee, do I have the right to stop my parents from selling their house before they die? And the answer to that is no. So even if there is a transfer on death deed in place, the legal owners of that property are still the original legal owners. We talked about yesterday that the person who's named as the recipient of that property at death doesn't assume the ownership of that property until the person or persons that were originally named on that property have passed away. It does happen automatically at that point, but it doesn't happen until that point. And any time up until that point, the people that own that property have the right to change that. So it's a revocable designation. They have a right to sell their property. They have a right to mortgage their property. They have a right to reverse mortgage their property. They have the right to do anything they want in that situation. Now, that is always subject to the lender, the reverse mortgage holder, potential purchasers review, but there is no legal restriction on that owner during life. Tanya?
One thing I think a couple of things. When we run title searches today and we find transfer on death deeds as a matter, like within the chain of title as part of our search, as Elizabeth mentioned, they don't come into effect until the persons are deceased, and at that point an affidavit's recorded, and that assists with transferring taxes and so forth. But the other thing to somewhat kind of keep in mind, and we've had this come up sort of as a surprise, is At the point in time the affidavit is recorded to bring into title or make that deed effective, if you will, as it relates to the county getting things transferred, judgments can then attach based on whoever's coming into title. So if I had signed a transfer on death deed to both of my adult children and I pass, when they come into title, if they have any judgments, federal tax liens, state tax warrants, those are things that can attach and impact the title to the property. So, if someone has some concern about executing a transfer on death deed because one of the children might have some issues that maybe the IRS is going to take what interest they have, that's kind of a consideration. But nothing like that transfers, or none of those judgments, things of that nature, attach when the deed is recorded. It's only when the affidavit is recorded upon their death. And I apologize, Elizabeth, I was answering something in a private chat, but that it's important to know that deed has to be recorded while you are still living. You have to execute it, place it of record in the county, and it has to be recorded before you die. There's no finding it in a drawer conveniently 3 weeks after somebody passed away and trying to record. It's null and void. So that's an important thing to keep in mind.
Yeah, you have to complete the transaction. All right, so now we're going to get into a little bit. Can we go back one slide, Gabby? Back to the estate slide. And this is the probate process. We talked about this a little bit when we talked about guardianships, but probate is a little different. And I do think there's an important distinction I want you all to be aware of, and that's between an estate that is supervised by the court and an estate that is unsupervised by the court. And that's a very important distinction in terms of how quickly someone can move through a transaction. So it used to be that when you were appointed as a personal representative, which is the new word for executor and executrix, so that's what you're going to see on all the documentation, is that the court would then approve of everything that the personal representative did. So when the personal representative wanted to buy things or sell things or pay things that were significant, they'd go to court and the court would say yes or no. That became very cumbersome and expensive. So what happened is that allowed for the evolution of what's called an unsupervised estate. And what an unsupervised estate allows is it allows the personal representative to transact the business of the estate without the court approving everything. Now, one important thing to know is that if at a later point there is a review of something that the personal representative did and the court determines that it's inappropriate, the personal representative then is personally responsible for that transaction. So the personal representative can't sell themselves the house for $10 because that's going to be subject to review at some point by the court if one of the other beneficiaries thinks that the transaction's inappropriate. So they still need to act appropriately and protect the interest of the beneficiaries, but they don't have to go into court. So if you're representing someone who is the personal representative of an estate and you're selling their property and they're in an unsupervised situation, then it's all right for that personal representative to accept an offer on that without writing those magic words subject to court approval. If the estate is supervised, you have to have those magic words in your acceptance, and it needs to say subject to court approval. And the way you know the difference is if you ask the person, the personal representative, for a copy of their letters, okay? And in the letters, there's a number there, a very long number. It's the cause number. In the middle of that number, there's an ES or an EU. EU is estate unsupervised. ES is estate supervised. So it's a quick and easy way for you to look at one piece of paper and know whether your personal representative is going to need to go through an approval process in regards to the sale or the purchase, or whether or not it's something that they already have the authority to do on their own. The other thing that it's important to know is that only a personal representative has the authority to sell property in an estate. I don't know what's going on right now, but we've had 2 situations in the last year where a beneficiary tried to sell some property and it wasn't theirs.
Happens all the time.
They could eventually receive the property or part of the property, but they don't own the property through the probate process. So until that transaction, until the property transfers to them, they don't have the right to list it, to purchase it, to accept an offer. They don't have the right to do any of that. Only the personal representative has that authority. The other important thing to know is that because the personal representative typically is not someone who's lived in the house or owned part of the house, when they transfer ownership of that property, they don't warrant. So there are very specific deeds that are used to transfer property through a purchase in an estate, and it is a personal representative's deed. And it's important that the purchaser of the property understand that they are buying through this process and not through a warranty deed situation. And I find a lot of the people that I know that purchase have no idea what the difference is here. So if you are representing a purchaser, I would hope that you use that opportunity to talk to them about the importance of that language. A warranty deed warrants that the title is clean and clear and has passed through, and everything that seller knows about that property has been conveyed appropriately to the purchaser. A personal representative's deed purely conveys title. It doesn't warrant, it doesn't guarantee. It makes, frankly, title insurance and some other insurances even more important in that process. So when you're representing the purchaser, you want to make sure that you really understand all the liability that purchaser is assuming, because the personal representative is not presumed under the law to know those things. Okay? So Tanya, do you want to talk any more to that?
I was going to say just a couple of things that I would add. Again, as part of the title search, we're going to pull any information that's available of record as it relates to whether or not it's a supervised estate or unsupervised, and we'll list any requirements as such. As Elizabeth mentioned, with an unsupervised estate, it's pretty straightforward. The only thing we will do prior to closing is make certain that it has not transferred into a supervised estate, because that can happen. It doesn't happen terribly often, but in the supervised estate situation, we do have to have appropriate documentation that will allow for the transfer of that property. The other thing to just kind of keep note of is we do have folks from time to time that get a little bit frustrated that we can't issue proceeds checks directly payable to the beneficiaries of the estate. The proceeds of the sale are required to go to the legal vested owner of record. So if my legal vested owner is the estate of Tanya Ott, then that's who the check's going to be payable to. It needs to be deposited or wired into an estate account, and that will be further distributed once the estate, is finishing up its affairs and so forth. We don't have to have, for tax reporting purposes, a lot of times there is a tax ID number that's assigned, and Elizabeth probably can speak to this far better than I. But typically a tax ID number is applied for an estate. Sometimes they are not. If they are not, then we do report under the deceased individual's Social Security number. So, and one other thing that I failed to mention on the transfer on death deeds, and it's a pretty common question that we run into, is that particular deed, when it's signed, removes the real estate from a last will and testament. Like, it is no longer an asset that's included in your last will and testament. So when that transfer on death deed is signed, recorded, that no longer leaves that particular property in the will to be, kind of dealt with later. It's already been spoken for, in a sense, by way of the transfer on death deed.
Exactly. All right, so let's talk about trusts. Trusts are a little different than anything that we've talked about today, in that a trust is not a court supervised entity like a guardianship or an estate. A trust is a separate legal entity. It's very similar to a corporation in terms of how it operates. It typically, again, has its own tax ID number. It has a trustee, and the trustee is the one who has legal authority in most situations to deal with the assets of the trust. So if there is a piece of property that's owned by a trust, usually it's the trustee. But this is where it gets a little sticky. So a trust can also say that, for example, if I have a trust for my children, but I have someone else in my life who I want to determine things about real property besides my trustee, I can name in my trust that that other person has authority over the real property. And depending on how that's worded, either the trustee still has the ownership of the property but not the control, which can be different. Ownership and control can be two separated things. Or the trust could be written so that the person that I've named has the ownership and control under that document, and they become kind of a de facto trustee. Sometimes they're called an investment manager, and their job is just to manage the investment of that real property. So one of the things that I think you'll see a lot when you have a trust involved in the transaction, especially as the seller, you are going to have usually the title company wanting an opportunity to review that trust so that they understand who has the real authority around that particular piece of property. So, and there are situations where sometimes the family doesn't want to relinquish the whole trust. So we'll use what's called a certificate of trust, where we put the information that just applies to that particular piece of property so that the title company can feel comfortable that they truly understand who has authority around that document, but they don't necessarily have all the dispositive provisions that frankly they wouldn't be that interested in anyway. So I think it's really important to know that a lot of times, especially if you have a trust that's selling a piece of property, that you make sure that the trustee knows that there's going to be a point in time when they need to share information about that trust, especially with the title company, in order to make sure that that title transfers appropriately. Tanya?
The only thing that I would add to that is, yes, we absolutely will request it, whether it's the buyer side or the seller side, to establish signing authority. And sometimes you'll find in trusts where multiple people are named as co-trustees. So you might have 2 or 3 different signers that are all required based on how that trust has been written, that are required to act in unison to sell the property. And one thing that we run into more often than what you would think is, we have a lot of folks that are remote or not local that want to use power of attorneys. And reviewing the trust, there are some trusts that are established in other states that will not allow for granting of a power of attorney. So it's really important that we do get as much of the trust documents as what we can to make certain that appropriate authority exists. And beyond that, a lot of times folks will send us a power of attorney that's already been signed in connection with the trust, but they've executed that document in a personal or individual capacity, as opposed to as trustee of the XYZ trust. So just some little different details and so forth, as it relates to that.
Okay, well, those are the entities that we wanted to talk with you about that we see become an issue. Now let's talk a little bit about taxes, because one of the questions that I get a lot is, all right, so what's the income tax implication of selling my property in these different situations? And so we want you to understand just a little bit about that. You might already know, and if you do, that's great, but just kind of a refresher. The first is that in any of these situations where you're representing someone who's still living, so in a power of attorney situation, in a guardianship situation, in any situation where it doesn't involve a death, the person's basis in that property for income tax purposes is the same as it's always been. So if I buy a property for $150,000 and 10 years later, I have a guardianship and it needs to be sold because I need to move into a different kind of facility, my basis is still $150,000 plus whatever improvements I've put onto that property. The same as it is for anybody that owns a house, and the same rules around the income tax of that gain or loss in that sale as it would apply for me as an individual still apply for the guardianship and everything else. Where the change comes is when someone dies. So if I own property when I die, we do have a different situation where you now get what's called a step up in basis when you die. So if I owned that property and I died and the property went from $150,000 to $300,000 in value, and that's what it was worth on the day that I passed away, then my basis goes from $150,000 up to $300,000. So my estate does not pay income tax on the difference between the $300,000 and the $150,000. So the income tax implications on that can be pretty significantly different, because obviously whoever's selling that doesn't get the same benefit of some of those exceptions, right, that we get when we're alive and we pass away. You know, I pass away, I sell my house for $100,000 more, I lived in it 5 to 7 years, I get all the rules, I get that $250,000 as an individual, $500,000 as a married couple. Obviously, if I'm the personal representative, I didn't live in the house for 5 to 7 years, so I wouldn't get those. So the step up in basis is really important, and it is important that your clients understand the tax implications. You do also, one other thing that's interesting is, let's say that I hold on to the property as the personal representative. We're in a bad market, I can't sell it. It was worth $300,000 when the person passed away, and when we actually sell it, it's worth $400,000, and it's 7 months after, I still get long-term capital gain treatment. So the holding period for that property goes back to the decedent. It doesn't go to the personal representative. So I still get long-term capital gain treatment. And I still get to deduct the expenses of the sale. So just some things about taxes we thought it might be interesting for you to know as you're talking to your clients about what they can expect to net, and why HUD statements and calculations might look a little bit different in an estate than it might when you're talking about a guardianship or a power of attorney situation. Okay. So that's my prepared comments for today. Tanya, would you like to share anything else?
I don't believe so. I think we kind of covered it slide by slide. So I'd be happy to answer any questions.
If anybody has any questions for Elizabeth and Tanya, please feel free to unmute yourself and ask your question, or you can put it in the chat and I will relay that message.
I've got one. Hello?
Yep, we can hear you.
You can hear you? Trust. Say there's 2 siblings, different states, and it's got both their names in there, and the terminology is and or with them. So being it says and or, does that mean I can pick one that's easiest to deal with and have them sign the listing agreement, the purchase agreement? Or is it going to come up at closing and or might mean, oh, we got to get all this other stuff signed? Or what's your interpretation of and or?
Tanya, you want to take that?
Well, what I would typically do is send it down to one of my underwriters to make the call on what they're comfortable with, because typically there might be a little bit more verbiage buried in. If the word or is in there, typically it would allow for only one to act, but off the cuff, it's really going to require looking at the whole thing. I mean,
Okay.
to be on the safe side, it wouldn't hurt to obviously have both from the beginning, but you might find once it's reviewed that only one has to participate from that point forward.
Okay, because it'll be like pre-listing, like before they even list the house, you have to have everybody sign the listing before you've got to that place with the title company. Or do you just, like I said, when we got the seller, it's kind of what I was chatting you about. When you got the seller, that doesn't mean I'm going to get to pick the title company. I can recommend it, so I could have you run the preliminary work, do a POA, have this stuff reviewed. What's Chicago Title's view on that? You take a chance on it that you'll get the work?
I was going to say, I mean, it's common that we run preliminary title work.
Yeah, I always have.
Yeah, in this marketplace, we obviously are hopeful that, we're going to be able to close the end transaction, and hope that, to the extent that it's able to note it somewhere, hopefully, a buyer would let you choose and would be happy with our policy, but it's a cost of doing business. So, I mean, as just like we don't close 100% of the deals that we open, right? Yeah. So even when people pick us, sometimes they fall apart, and, it doesn't, but it's just a cost of doing business.
Yeah, I know Jamie, and she's always been good about that with you guys. Got time for another one?
Sure.
Probably more for Elizabeth, but maybe you've seen this too, Tanya. I actually have two of these senior stills that are paralyzed with now the elders are both all deceased, and they both have one sibling that for different reasons won't move out. Been a year and a half, they're paralyzed. They claim they're going to buy it. It's just going on and on. I've distanced myself from this, and all I can tell them is attorney. And I guess what I'm getting from them, they talked to an attorney that said they can write a nasty letter, but there's really no teeth to it. Is that how you see this? Have you ever seen this situation?
So are you talking about that a couple of people own the home together?
The parents died, and there's multiple siblings, and the siblings did live there with the mom.
Okay.
So I don't know if that gets into a 2-year caregiver complication. But long story short, we can't sell the house yet because there's one sibling that won't leave, and we can't really trust them that they'll leave after we get an assigned or an accepted offer.
So my practical approach to that is that because all the siblings own the house in that situation and one is living there, that we start to charge rent. And when they don't pay rent, we evict. And that's how we get them out of the house.
So she would have to contact her attorney maybe and send a letter or somehow. How do you do that?
So in Indiana, there is a month-to-month default rental statute. And so the attorney sends a notification to the tenant that the expectation is that they will pay full market rent each month on time. And that the first time that they miss that full market rent, the expectation is that they will be evicted for non-payment of rent within 15 days. So there are ways to deal with that. Now, I will say that does not make Thanksgiving very fun.
No, it's already getting to that place.
Well, so if there's any other way to do that, we highly encourage that. But sometimes there isn't another way to do that.
Yeah,
no one gets to live in a property that's owned by someone else, even partially, without paying for it.
Even if they claim they were there 2 years as a caregiver?
I don't care.
Okay, got it.
As long as mom and dad are dead, the caregiver statute does not extend beyond death.
Okay, all right. That's good information. I appreciate that.
Thank you, Richard, for that question. Does anybody else have a question you want to put out there to these two?
One last, if you don't mind, Elizabeth. That was a great presentation. Tanya, thanks too. I got distracted when you were talking about the tax consequences when a person dies.
Mm-hmm.
So you got a stepped up value. What happens there? Is it?
So what happens is it steps up to the fair market value on the date of death that the person passed away.
Okay.
So if I own a piece of property, and even if I own it for 50 years before I die and it appreciates 1,000%, whatever that value was, that's the basis, the new basis for my heirs, whoever they are. And so if they sell it right away and they sell it for exactly that value, there is no income tax consequence to them whatsoever on the sale. And what's nice is some expenses that estates incur can be taken on an estate income tax return against income from maybe other assets that the person had, and it can negate some other income tax liability. So your attorney and your CPA that are dealing with the estate can help walk you through that. But I think it is important when you're setting expectations, especially on purchase price and on what people are going to net. Sometimes if you know you don't have to pay tax, it's a little easier to take a little less because you know you're going to net more. So it's just, I think it's nice for you all to know that as you're talking to your client about what the realistic expectations of what they'll receive out of the transaction are going to be.
So if the stepped-up value is $300,000 at the time of death and they sell for $400,000, they pay tax on that 100?
They do pay tax on the 100, and they pay that as long-term capital gain tax rate. So that's the other advantage is if they're in a higher income tax bracket, they're not paying it at their ordinary income tax where they might be. You know, normally when you only hold an asset for 6 months, you don't get long-term capital gain tax treatment, right? You haven't held it long enough. But in the case of an estate, you get to take all of that holding period from the decedent. So it's assumed that any gain there is going to be taxed at a long-term capital gain tax rate as opposed to an ordinary income tax rate.
Perfect.
Okay.
So that's what I forgot.
So if just seniors, I'm sorry. If the seniors sell a paid-for house before they die, then they're not going to be paying taxes. But if they die,
no. If they qualify, remember we have those exemptions, right? 250 and 500,000.
Okay.
But if you hold it for an amount of time and your gain is not less than that, like I have a client who had a home in Florida that she bought 40 years ago for $350,000 and just sold it for $2.5 million, and she's paying a lot of tax because it's way over her exemption amount. If she held that house until she died and her children sold it for the $2.5 million, no one would pay tax.
Was that her primary residence?
It was.
Okay. All right.
So you don't get to exclude all the gain on your primary residence, right? You get to exclude some, but you don't get to exclude it all. There's limitations in terms of holding periods and how much. And I would highly encourage you to involve the CPA or the tax professional that's helping with the estate in that conversation to kind of do maybe a little pro forma for you to show the beneficiaries what they'll receive in different situations. But just so you know, that's how that works.
Okay.
All right, thank you everybody for joining us this afternoon. Give Tanya and Elizabeth a virtual round of applause for being our speakers today. My camera went out several minutes in and I was afraid to fix it in case we would completely go down. I will follow up with all of you. You should hear from the foundation with links to all 3 presentations. I'll also include contact information for all of our speakers so that you can follow up with them if you have other questions or need support in this area. And our Starbucks gift card winner today is Loretta Miller. So Loretta, look for an email from me with your Starbucks gift card. Thank you, Elizabeth and Tanya, so much. Everybody have a great afternoon.
Thank you for
having me.